Can a 1798 law be used to mass arrest and deport illegal aliens? The law at issue is an act that implements the internationally recognized right of every nation to protect itself during times of war from individuals whose primary allegiance lies with a hostile foreign power. That law is what we will look at today, given the attention brought to the law by President Trump in the 2024 election, and the discussion about the illegal immigration problems in the country. Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is one stemming from our Curious Lawyer series, and is a look at the fascinating legal questions raised by the Alien Enemies Act of 1789, the questions about invocation of it by a president to address the illegal immigration problem. This has been all over the press in recent years, and you, the curious lawyer, need to be able to answer questions at cocktail parties or when non-lawyer friends ask. No spin here, no politics, just the straight analysis of the law so you can decide for yourself the likely outcome. We ultimately ask, how have courts treated this old law, how much deference is given the president, and what is the likely outcome if the president declares an invasion? So sit back, and after this hour, you will know all the key points about the law, the case law, and the role and limits of the judiciary in looking at these issues. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs, and, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education. That is often technical, difficult, or stressful. So sit back and grab a cocktail if you are so inclined, and let's get going. Let's start with our agenda today of what we are covering. We are looking at the statute and the limited case law that has interpreted it. We will go into the statute more, but I want to give it to you out of the gate so you can see the key language that drives the issues we will address. It says, quote, Whenever there is a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion is perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the President makes public proclamation of the event, all natives, citizens, denizens, or subjects of the hostile nation or government, being males of the age of 14 years and upward, who shall be within the United States and not actually naturalized, shall be liable to be apprehended, restrained, secured, and removed as alien enemies." End quote. As you see, there are two prongs, the war prong and the invasion prong. And each of those litmus tests allows the President to order all people over 14 who come from the foreign nation we are at war with or invaded by to be arrested, detained, and then removed. The two prongs are very important because, as we will see in the limited case law, it revolves solely around the war prong. We will therefore look at the case law to understand the scope of judicial review, how expansive it is or how limited it is, which requires us to consider as courts have the political question stay out of political questions, period, ultimately looking at the case law and the way the war prong has been interpreted. We will look at the arguments for and against the use of the invasion prong, given our 21st century facts relating to illegal immigration problems in America. And also out of the gate, it facially does not just apply to mass illegal immigration, so it is not a tool to use to address mass illegal migration in itself. So the question we must stay focused on as we walk through this thicket of law is whether a foreign nation or government is conducting an invasion of predatory incursion. That is, there is a nation-state-based nexus facially to the statute. Finally, one point out of the gate. This law was not the law used in World War II to intern Japanese Americans. That was done by a different presidential executive order, which led to the famed Koreamatsu case upholding the detentions. This law we are looking at today in this program instead deals only with non-United States citizens who are from foreign lands. Let's take a look now at the background of the Act. It was passed in 1798 as part of the Alien and Sedition Acts of 1798, and it was signed into law by President Adams. The context to all of these acts is that the United States was on the brink of war with France, and there was generalized fear about pro-France supporters in the United States. As a result, various laws were passed in an effort to ostensibly protect the United States from potential French spies or pro-French supporters. The statutes, of course, as you know from history, were contentious, including particularly the Alien and Sedition Act, with arguments relating to whether it violated the First Amendment. Most of the statutes passed were limited in time. But the one that did not have a time limit was the Alien Enemies Act of 1798, and so it has survived until today. It has been used a few times by the executive in history. In connection with wars, as we will see, the war prong is invoked by the president to issue rules and instructions and structures in terms of dealing with what are labeled enemy aliens, that is, non-citizens from the country that is our enemy in that given war. So now back to our statute again. There are 4 parts to the statute, sections 21 through 24, and we will look at all of them. The main one, of course, is section 21. Here again, we see the war prong and the invasion prong, which allow the president, if either is triggered, to apprehend, detain, and ultimately remove natives or citizens of the hostile nation at issue. When the statute was originally passed, it specifically referred only to males over the age of 14, and that was amended in 1918 to cover all people over the age of 14. The question we are asking is, what is the scope of the invasion prong? Obviously, when we are not at formal war with a country as declared by Congress, the question is, what does the invasion language mean? Does it mean literally the way we understand the word today, that a large number of people may come in and in some non-literal sense invade our country? Or does it have a specific meaning as understood at the time that relates to war-related efforts by a foreign country? These are the questions we will look at and try to answer as we walk through the statute and the case law. Let's keep going with our section 21 because, as you can see, if it is triggered, the president is allowed by proclamation to establish the rules and manner that define the nature of the restraint of enemy aliens and how they can be removed. Now let's look at section 22. It provides that when an alien who becomes liable as an enemy in the manner prescribed in the preceding section is not chargeable with actual hostility or other crime against the public safety, he shall be allowed, for the recovery, disposal, and removal of his goods and effects, and for his departure, the full time which is or shall be stipulated by any treaty then in force between the United States and the hostile nation or government of which he is a native citizen, denizen, or subject. And when no such treaty exists or is in force, the President may ascertain and declare such reasonable time as may be consistent with the public safety and according to the dictates of humanity and national hospitality. What does this mean? In essence, Section 22 is a limiting principle on Section 21. Section 21 defines the broad range of powers the President has to deal with enemy aliens. But Section 22 makes clear that if the enemy alien is not someone who's actually engaged in public safety crimes or open hostility against the government, that person is given some amount of time to settle their affairs in essence, either based on existing treaties between the United States and the country at issue, or if there is no such treaty, then a reasonable time as declared by the President. In other words, if the enemy alien is not a threat, they are entitled to some amount of time to get their affairs in order before they are actually removed from the country. Now let's take a look at Section 23, which is titled Jurisdiction of United States Courts and Judges. This is an important section because one of the issues that we will see in the case law is the scope of judicial review of a presidential invocation of a Section 21 finding. It says, quote, "After any such proclamation has been made, the several courts of the United States, having criminal jurisdiction, and the several justices and judges of the courts of the United States are authorized, and it shall be their duty, upon complaint against any alien enemy resident and at large within such jurisdiction or district, to the danger of the public peace or safety, and contrary to the tenor or intent of such proclamation, or other regulations which the President may have established, to cause such alien to be duly apprehended and conveyed before such court, judge, or justice, and after a full examination and hearing on such complaint, and sufficient cause appearing, to order such alien to be removed out of the territory of the United States, or to give sureties for his good behavior, or to be otherwise restrained, conformably to the proclamation or regulations established as aforesaid, and to imprison or otherwise secure such alien, until the order which may be so made shall be performed." End quote. Now, I highlighted important language for you here because, as you can see, Section 23 does, by its title itself, vest jurisdiction in courts and judges to assess some aspects of a Section 21 finding. And as you can see in the bolded language, it provides that the judges, upon a full examination and hearing of a complaint made by someone that they are improperly being removed, is then able to assess the question and order the imprisonment or removal. The question we will look at is, what is the scope of that examination and hearing that the United States judiciary may make when a situation arises? In other words, a Section 21 declaration, are the courts allowed to assess whether it really is or proper war? Or must they simply accept that the judicial inquiry is limited to assessing whether there actually has been a declaration of war and whether the person is a citizen of a foreign nation or not? Those are more narrow jurisdictional questions, of course. But as you can immediately see, it will become very important in understanding the role of the judiciary in assessing a hypothetical presidential declaration of an invasion or predatory incursion under the second prong if that was to happen. Would courts be allowed to second-guess the President's declaration of an invasion or predatory incursion? Would courts get to define what is an invasion within the statute? That is, if the President was to say that an invasion or predatory incursion occurred, would the courts be allowed to redefine the President's understanding of those words and therefore conclude that the President is wrong in that assessment? These are the fascinating and complicated questions that drive the analysis, called the questions, as you can see, that are more complicated than the question of whether a war exists, which is in many respects a light switch event. If Congress declares war, there is a war, and there's nothing for a court to look at. But since the Constitution does not demand Congress be involved in declaring an invasion, we are left with the more thorny question of the role of the courts versus the President in defining and examining this question. Finally, we can look at Section 24, which describes the duty of the United States Marshals when the President issues a Section 21 proclamation, or when a court addresses the case of an enemy alien being detained or removed due to the Section 21 proclamation. It says, quote, "When an alien enemy is required by the President, or by order of any court, judge, or justice, to depart and to be removed, it shall be the duty of the marshal of the district in which he shall be apprehended to provide therefor, and to execute such order in person, or by his deputy or other discreet person, to be employed by him, by causing a removal of such alien out of the territory of the United States. And for such removal, the marshal shall have the warrant of the President, or of the court, judge, or justice ordering the same, as the case may be." End quote. The bottom line here in Section 24 is that if we are in a Section 21 proclamation situation, the marshals work for the President in executing those orders of removal. So let us now do a quick recap so that the issues can be framed as we start looking at the case law. Remember, we have two prongs. If a war is declared between the United States and another country is one prong, or as our second prong if there is an invasion or predatory incursion perpetrated, attempted, or threatened by a foreign nation or government against the United States. If either of those two prongs are satisfied, then the executive can make the public statement and proclamation of that and order the arrest and detention and removal of those over the age of 14 who are not U.S. citizens and are instead citizens of the foreign nation. The executive gets to issue the rules on the conduct of this process. But remember, if the person arrested is not an actual warrior fighting against us or a public threat, then they do have the right to some amount of reasonable time to get their fighting against us, or a public threat. Then they do have the right to some amount of reasonable time to get their affairs in order before removed. And courts have jurisdiction to look at cases under Section 23. The issues, therefore, that we are circling around relate to W-hat is the scope of the jurisdiction of the courts. What is the realm of political questions that belong to the executive and not the judiciary in terms of deciding whether a predicate war or invasion actually exists? Who decides that question? How much judicial review of that question is available? Or are courts limited only to looking at whether people are citizens and over the age of 14 of a foreign country upon a declaration of war or invasion? Or do courts get to look behind the declaration of war or invasion and assess whether there is in fact a war or invasion underway? Ultimately, do our courts have some sort of supervisory role coming from Section 23 to address the legitimacy of an executive determination of an invasion? And if so, what would that even look like? And how much is reasonable time to allow people to get their affairs in order? Some of these questions we have answers from courts on, but some of them we do not. The reason for this is that the only case law we have relates to the war prong under this act, as there has never been a case litigated over the scope of a presidential proclamation of an invasion or predatory incursion. So we are on a blank slate here and have to look at the existing case law in the war context to read the tea leaves about how all of this would apply in the invasion prong context in the 21st century. As I mentioned, we have 3 instances where a presidential Section 21 proclamation has issued, and which has resulted in some litigation in the courts. So now let's take a look at our 3 examples from history and the resulting case law to help us answer these thorny questions. The first of the 3 historical examples where Section 21 was invoked was in the War of 1812, and this was when President Madison issued a proclamation with respect to expected British enemies within the United States. His proclamation required British citizens to report and register information about themselves with the government. Now, of course, the War of 1812 under the Constitution, which precipitated the President's invocation of Section 21. In turn, this proclamation led to some litigation, and the first reported case involving the Enemy Alien Act was in 1817, and is the case of Lockington versus Smith. You can see the citation here. Before we get to the basic facts and what happened, one overarching principle is important. The case involved a prolonged detention without deportation or removal back to England. The overarching principle that the court held is that, as you can see here, quote, "The power of the President under the first section of the law, to establish by his proclamation or other public acts, rules, and regulations for apprehending, restraining, securing, and removing alien enemies, under the circumstances stated in that section, appears to me to be as unlimited as the legislature could make it. It seems perfectly clear that the power to remove was vested in the president, because under certain circumstances, he might deem that measure most effectual to guard the public safety. But he might also cause the alien to be restrained or confined if in his opinion the public good should forbid his removal." End quote. So as a large framing principle before we get into the case, what we can see is that the first court to look at this law concluded that this was a massive vest of discretion in the president to make these determinations as to whether people should be detained or removed or both. Let's now take a look at the facts of the case and get into it deeper. The basic facts are as follows. The plaintiff in this case was a British citizen, and after the proclamation of war and the registration requirement issued by the president under Section 21, he registered with the government. However, the rules issued by the president require people to stay a certain distance away from the shore and tidewaters. This plaintiff failed to do it, was arrested, and was imprisoned. He then sought release under Section 23 in a federal court action, arguing that he was detained too long and should be removed to England. As you saw already in the prior slide, the first thing the court concluded is that the president has vast discretion to direct the conduct of how people are detained and/or removed. But the scope of the executive power goes further, as this case held. It is a provision for the public safety, which may require that the alien should not be removed, but kept in the country under proper restraints. It is never to be forgotten that the main object of the law is to provide for the safety of the country from enemies who are suffered to remain within it. In order to effect this safety, it might be necessary to act on sudden emergencies. The president, being best acquainted with the danger to be apprehended, is best able to judge of the emergency which might render such measures necessary. Accordingly, we find that the powers vested in him are expressed in the most comprehensive terms. This, of course, is a massive statement of deep deference from the courts to the executive in terms of being the person to apprehend the dangers and act accordingly with limited judicial review. And with respect to the plaintiff's argument that was put to the federal court, that the courts must look to the regulations created by the president and enforce them and allow his removal, the judge in this case held that quote. Such a construction would, in my opinion, be at variance with the spirit as well as with the letter of the law, the great object of which was to provide for the public safety by imposing such restraints upon alien enemies as the chief executive magistrate of the United States might think necessary, and of which his particular situation enabled him best to judge." End quote. And here is the powerful line on deference as articulated by the Lockington Court. The Alien Enemies Act appears to me to be as unlimited as the legislature could make it. This is grant of deep deference to the president on his discretion to use the act and a limit on a court's ability to check that act of discretion. Now it turns out the act would lay dormant for nearly another century until World War I, which brings us to the second utilization of the act in subsequent cases discussing it. In 1917, Congress declared war on Germany and other European powers and joined World War I period at the time President Woodrow Wilson issued a proclamation under Section 21. Under his proclamation, he declared that any alien enemies in the country who may be believed to be supporting the German war effort would be subject to summary arrests, confinement in prison, or in a military camp. There was also a registration requirement, and the National Archives indicate that around 480,000 Germans in the United States registered with the government. In total, around 6,000 were actually detained. And if you want to read more about that, you can at the National Archives article I have linked here for you. President Wilson's proclamation also prohibited enemy aliens from possessing firearms or ammunition, using wireless devices, and using aircrafts, period. This was in addition to the registration requirement, of course. Now, as a quick aside, at this time also the Enemy Alien Act was amended to remove the word males so that it would apply to all genders. It appears the Founding Fathers were only concerned with male enemies, but by World War I, the president was concerned about both genders potentially being involved in espionage or spying activities. So let's now take a look at one of the early cases to come out of President Wilson's Section 21 proclamation, and this is Lacey versus United States. This case involved some plaintiffs who were indicted for aiding and abetting the escape of some Germans who had been detained under Section 21 period. Now the parties who had been indicted argued that the Alien Enemy Act of 1798 was unconstitutional and deprived people of liberty without due process of law. If they could show that the act as applied to the detained Germans was unconstitutional, then they could not be indicted, obviously, for aiding and abetting a violation of that law. What did the court hold as to the constitutionality of the act? It found the law constitutional. Here is what the Ninth Circuit said. Quote, starting at the second sentence, while as to property rights and life and liberty, all aliens domiciled in the United States, or temporarily therein, are accorded the equal protection of the law and due process of law, such is not the case as to alien enemies. Alien enemies have no rights and no privileges unless by special favor during time of war. Such was the common law. Alien enemies have no rights, no privileges, unless by the king's special favor during time of war. And you see there a citation to Blackstone and Old Common Law. Continuing, quote, there is nothing in the Constitution or laws of the United States which in any way has changed the common law rule, or restricted the power of Congress to enact the alien enemy law. Power to enact such a law may at times be essential to the preservation of the government, and the right of all nations to exercise it is recognized in international law. End quote. So that is a clear holding that the law itself was completely constitutional and was the codification of ancient common law that concluded during the time of war, enemy aliens have no rights or privileges unless granted by special favor. If we look at this case of Graybar, this was one of the first decisions in the World War I era addressing the act. Here, a Croatian had been detained and argued that he had intended to become a naturalized citizen when he entered in 1903, but never was able to do it, and so he should not be considered an alien enemy. But the court refused to look at his loyalty to the United States and simply concluded that since he was a citizen of an enemy state, the inquiry ended. You can see the quote here that says that the executive's determination that he is an enemy alien is final and conclusive, and not subject to the review of the courts. In other words, the courts only look at jurisdictional facts and not more. And in another case called Reese from New York, here the court looked at who has the burden. This case explained that as between who has the burden, specifically, is it on the alien enemy to prove he is not an alien enemy, or is it on the government to prove that he is in fact one? This court concluded that, given the nature of the statute giving expansive powers in a time of war, it must be that the presumption is that the president acts lawfully, and people who are detained are lawfully detained, such that the burden therefore is on the person detained to show that somehow they are not a citizen of the state they are claimed to be a citizen of, or that there is not a war, for example. This case was important because the person detained claimed to have been born in Mexico and so was not a German enemy alien. But the court looked at all the facts and ultimately concluded that it was unable to affirmatively find that he was not Mexican. That is, he may have been Mexican, but also he may have been a citizen of Germany, even though the court could not affirmatively conclude he was indeed a citizen of Germany. But because of where the burdens existed, it was the petitioner's burden to show that he was indeed not a citizen of Germany, and this court ultimately concluded that he couldn't rebut the government's conclusion that he was, even if the court did not know for sure one way or the other. This now brings us to the third major episode in American history, where the Section 21 proclamation was issued, and this is during World War II by President Roosevelt. Here, in a series of 3 proclamations, President Roosevelt deemed the Japanese, German, and Italians who were non-citizens in the United States to be alien enemies, and therefore required registration with the government, and they were subjected to a series of regulations that restricted their activities, as in the similar prior proclamations we have looked at. The proclamation also specifically permitted summary apprehension and internment for the duration of the war any such enemy aliens if they were perceived as being dangerous to the peace or security of the United States. Let's take a look at the proclamation as to Japanese citizens in the United States. This was issued on December 7th, 1941, literally right after Pearl Harbor occurred, and so you can see it as one of the first things that the government did in response to the attack on Pearl Harbor. And here you have a quote of part of Proclamation 2525. Quote, "Now therefore I, Franklin D. Roosevelt, as President of the United States and as Commander-in-Chief of the Army and Navy of the United States, do hereby make public proclamation to all whom it may concern that an invasion has been perpetrated upon the territory of the United States by Empire of Japan." A list of things was prohibited, including no possession of weapons, radios, cameras, no flying in airplanes. Enemy aliens deemed dangerous can be summarily apprehended. Not allowed to go in non-public areas. So let's take a look now at the seminal case that went to the United States Supreme Court on the act during the war. Here are the basic facts of this case. The petitioner, a German, was arrested in 1941 and placed in an internment camp in 1942. He was then ordered to be deported to Germany in 1946. However, he argued that he could not be returned to Germany because the war had ended in 1945, and so his continued detention was unconstitutional, and he had to be released. His claim was rejected in a 5-4 decision by the Supreme Court. There are 4 key points the majority make. First, the language employed by the Fifth Congress could hardly be made clearer or be rendered doubtful. The act concerning alien enemies, which confers on the President very great discretionary powers respecting their persons, appears to me to be as unlimited as the legislature could make it. Second, quote, "The very nature of the President's power to order the removal of all enemy aliens rejects the notion that courts may pass judgment upon the exercise of his discretion." End quote. Third, war does not cease with a ceasefire order, and power to be exercised by the President, such as that conferred by the Act of 1798, is a process which begins when war is declared but is not exhausted when the shooting stops. Its termination is a political act. Fourth, whether and when it would be open to this court to find that a war, though merely formally kept alive, had in fact ended, is a question too fraught with gravity even to be adequately formulated when not compelled. These are matters of political judgment for which judges have neither technical competence nor official responsibility. These are very powerful points. What is important here is the court noted that war could be terminated by treaty or legislation from Congress or even a presidential proclamation, and specifically however it is to be terminated, that is a political act too fraught for a court to wade into. That is powerful language. And we should pause and double-click on that because that casts a potentially long shadow over prong 2's invasion question. The same analysis could apply there, whereby a court concludes that the beginning and termination of a quote, end quote, invasion is a political act for the other branches of government to adjudicate, not the courts. The argument that this case could support the power to arrest and detain certain without judicial scrutiny would therefore rely on this language and structure. Now, the court also addressed the voiced concern from both the dissenters and the petitioning party that war powers could be abused by the president, and so therefore, judges needed to be more involved in supervising this exercise of discretion under this act, in order to make sure the executive does not overreach. The court specifically rejected that argument and cited to an old case from the 18th century with a quote that's worth us reading here. "All systems of government suppose they are to be administered by men of common sense and common honesty. In our country, as all ultimately depends on the voice of the people, they have it in their power, and it is to be presumed they generally will choose men of this description. But if they will not, the case, to be sure, is without remedy. If they choose fools, they will have foolish laws. If they choose knaves, they will have knavish ones. But this can never be the case until they are generally fools or knaves themselves, which, thank God, is not likely ever to become the character of the American people." End quote. So then, for a bottom-line holding, the petitioner lost because even though the war had ended in terms of bullets being fired, the president still decided in 1946 that the Section 21 structure should stay in place, and until he decided otherwise or Congress formally declared the end of war, the courts had no business being involved. This is both structural deference on Section 21 decisions about the triggering event, here war, and also the limit or a court's role on the triggering event determination. Now, this case had 4 dissenters, so it was by no means a slam dunk. Let's look now at the dissenters and what they said. The dissenters were Justices Black, Murphy, Douglas, and Rutledge. They said, "I think the idea that we are still at war with Germany in the sense contemplated by the statute controlling here is a pure fiction. German aliens could not now, if they would, aid the German government in war hostilities against the United States. The 1798 Act did not grant its extraordinary and dangerous powers to be used during the period of fictional wars." End quote. What is important in this conclusion of the 4 dissenting justices is that the courts do get to pull back the curtain and look behind through a quote, war end quote determination. They do not need to be bound by the other branches of government and their adjudications of that question. Indeed, here, as you can see, the dissenters said that since all hostilities ended in 1945, they believed that it was a fiction to even say that a war still existed, and so therefore they concluded that the courts should be able to actually say that the war was over, and therefore the Section 21 power had ended. And so as a result, the complaining party could no longer be removed or detained. The dissent also said this, quote, "The notion that the discretion of any officer of government can override due process is foreign to our system. It is well established that the war power does not remove constitutional limitations safeguarding essential liberties." End quote. You can see the obvious long shadow cast by that argument that would cut against the ability for the executive to make a unilateral invasion determination without judicial review period, but at the same time, this was a set of dissenting justices and not the majority. In another case involving German enemy aliens and World War II, we again have a chance to look at the scope of a federal court's ability to peer into the question of whether a war exists or has ended. This case comes up in a slightly different context, but is also important period, and of course it was a U.S. Supreme Court case. Here are the basic facts. Plaintiffs alleged that prior to May 8, 1945, they were in the service of German armed forces in China. Post-surrender by Germany, they continued to fight. They were convicted of violating laws of war by engaging in, permitting, or ordering continued military activity against the United States after surrender of Germany and before surrender of Japan. Their hostile operations consisted principally of collecting and furnishing intelligence concerning American forces and their movements to the Japanese armed forces. After the Japanese surrender, they were caught and convicted and sent to prison. They argued a variety of constitutional claims outside the context of our Enemy Alien Act, but the court did address the Enemy Alien Act in part in resolving the case. Here is what the Supreme Court said that is important today, of course. The resident enemy alien is constitutionally subject to summary arrest, internment, and deportation whenever a declared war exists. Courts will entertain his plea for freedom from executive custody only to ascertain the existence of a state of war and whether he is an alien enemy and so subject to the Alien Enemy Act. Once these jurisdictional elements have been determined, courts will not inquire into any other issue as to his internment." End quote. That is a further important principle that courts look only to the jurisdictional facts. Does a state of war exist? By looking to what the Congress or President has said? And is the person at issue an enemy alien? A narrow view of those questions delimits federal court inquiry. Here's what the Supreme Court also said as a key framing policy principle to delimit litigation and court enmeshment. Executive power over enemy aliens, undelayed and unhampered by litigation, has been deemed throughout our history essential to wartime security. That's at page 774. And reflects judicial concern over limiting federal court involvement on war security issues that the executive deems necessary. It also ruled that, quote, "the essential pattern for seasonable executive constraint of enemy aliens, not on the basis of individual prepossessions for their native land, but on the basis of political and legal relations to the enemy government, was laid down in the very earliest days of the Republic and has endured to this day." It was established by the Alien Enemy Act of 1798. End quote. Of course, the complexity we confront is what happens when it is not a congressionally declared war, and instead we are under a hypothetical presidential declaration of invasion. Now, of course, we are asking the question of when does a war ultimately end? Surely at some point it ends and the courts can say it has ended. And we can look at our third case from the United States Supreme Court from 1952 now, where the limit of the court's ability to adjudicate that question is seen. Here are the basic facts. Defendant Carusi was arrested and interned in 1942. In 1946, he was ordered removed to Germany. While the case was pending still in 1951, Congress formally declared World War II was over. The government still sought to remove him, and he argued that with congressional termination of the war, the Section 21 power over him was over. And here the Supreme Court agreed. But what is important is that it held that the power to continue exercising decisions under Section 21 proclamations simply comes to an end when Congress terminated the war period. So what we can see is the court did assess the question of whether the war was over. But the methodology to determine that was to simply look to what Congress had said. In essence, it is a light switch inquiry. And as we saw in the prior case, until Congress did that, the court would not get into the mushy actual question of whether a war has ended when bullets are no longer flying, but the president or Congress is still saying there is a war. Here we have an important case that deals with the distinction between Section 23 jurisdiction of courts over the president's proclamation or an actual court case. And what this court, the Second Circuit, said in 1946 is that the only question that courts can look at is when an action is actually filed by someone contesting what has happened to them. Then the court may exercise that Section 23 jurisdiction to look at the issue. Other than that, the executive action is off limits. Here we have the question of whether 30 days to leave is reasonable. Here we have a German citizen who was born in Dresden, Germany, and lawfully entered in 1930. He was mistakenly inducted into the United States Army on July 31st, 1942, and was in that service until November 12th, 1942, when he was honorably discharged because of the previous mistake in inducting an enemy alien. Then, he was interned under the Section 21 proclamation to enter enemy aliens until 1949, and then he was slated to be deported. He argued that the war was over, so he could not be removed. He lost on that because of the Supreme Court ruling in Watkins that we have already looked at. But he also argued for more time. The Second Circuit here held that 30 days was reasonable. We think 30 days is prima facie a reasonable time, and that the order is valid in this respect, since no special circumstances have been shown to make the period unreasonable as to this appellant. So if the Section 21 proclamation and implementing rules say 30 days is sufficient to get one's affairs in order, pre-removal, the court here said 30 days is fine. Now that case was in 1949, but here is a case from the year before from the same Second Circuit, which seems to be even more restrictive. Here, the Second Circuit noted that the 30-day time period to leave was deemed reasonable by the Attorney General, and so therefore it was not even subject to court review. This would imply that whatever the executive deems as being a reasonable amount of time is within its discretion, and not for the courts to even second-guess. So here you see we may even have a slight split in how the cases look at the question as to whether it's something that the courts can even review for reasonableness or not. Let's take these principles now and turn to the question that we have been pondering, and that is the scope of judicial review if there is a presidential Section 21 proclamation with respect to the second prong of Section 21, the invasion prong. Now, of course, the war prong is the easiest case because Congress is required under the Constitution to declare a war if the country is to formally be in a war period, but there is no similar provision for an invasion or a predatory incursion as the language is written in Section 21. So we cannot look to a light switch event of whether Congress did something or did not do something to know whether the Section 21 power has been exercised properly. The first question we have to consider is whether the invasion or predatory incursion language itself requires the context of an actual declared war, or does it apply to non-declared war situations that are perhaps preparatory to war, but not yet at the point of a formal federal congressional declaration of war. This raises the question of what exactly does the language even mean? And of course, the language also requires that an invasion or predatory incursion be done by a foreign nation or government, as opposed to individuals or citizens of that foreign country. So the focus is on foreign governmental invasions or predatory incursions into our country. This, by definition, narrows any broad use of Section 21 to combat what is fundamentally an immigration issue. The question then this raises is, could foreign gangs be deemed a foreign nation, and if so, how? Or perhaps, could a foreign government that decides to empty its prisons of a particular group of people and actively encourage or ask them to go into America, would that be Section 21 triggering language? And if the president made a finding on his record that these things happened by a foreign government, how limited would court inquiry be into that finding? And the important question then becomes, if such findings and proclamations are made by the executive of those types of events, what is the scope of review of a federal court as to those questions? Would it be limited strictly to a jurisdictional thin inquiry as we saw in the cases throughout history? Or would the court actually look deeper, pull back the curtains, as the dissenters in the seminal Supreme Court case argued, to really figure out if there is an invasion by a foreign government or a predatory incursion by a foreign government afoot? Remember those cases that we looked at that go from the 1800s to the early 1900s to post-World War II talk constantly about the extreme breadth of deference given to the executive. And so we have to wonder today, would the dissenters' view control today a federal court inquiry in light of the fact that there is an invasion, in other words, there's no external source in the legislative branch that we can go to conclude that they have voted on the existence of such an event? Of course, even that may not be true, because the Congress could vote and make a finding or resolution of some kind that it believes is an invasion or predatory incursion has occurred by a foreign government in a particular specific circumstance involving certain groups of illegal aliens entering the United States. In that case, we would have to ask then if the courts could second-guess that. These are all the thorny questions that we are now confronting. So let's double-click on some of this and go deeper. Let's unpackage then the arguments for and against a presidential use of this law to mass arrest or deport aliens in more detail. And let's first explore the working definition of invasion. Whereas war is defined structurally in the sense that Congress declares it, invasion is not, as we discussed. And as noted, there have been no cases addressing it, nor does the statute itself actually define it. So what is an invasion exactly? Is it a political question reserved to the courts? Or is there some definition that we can divine from other areas of the Constitution? It turns out there are other sources we can look at to help illuminate at least arguments about the meaning of the phrase. If we go to some founding era definitions from dictionaries, we can see that Madison defined an invasion as an operation of war, and other dictionaries from the time define invasion as relating to hostile foreign military sources or hostile encroachments. And we do have other constitutional provisions that use the word invasion, so we can look at these two areas of the Constitution and see what courts have said about another part of the Constitution at a very close time frame to when the statute was passed. Specifically, we have the Invasion Clause and the Guarantee Clause of the Constitution. The Invasion Clause says that no state can engage in war without Congress's consent unless that state is, quote, actually invaded, end quote. And the Guarantee Clause of the Constitution says that the federal government has to guarantee the Republican form of government to the states and, quote, protect against invasion, end quote. Let's take a look now at some case law that has discussed the meaning of the word invasion in the context at least of these provisions in the Constitution. You see here our first case is from the Second Circuit, and it says that in order for a state to get the benefits of the Invasion Clause, it has to be exposed to armed hostility from another political entity, such as another state or foreign country intending to overthrow the state. That definition of invasion, if imported into the Alien and Enemies Act, would require actual armed hostility from the government in question coming into the United States, which is a narrower definition of invasion than its colloquially perhaps use. Now, here is an important point that comes from these cases, though. The Ninth Circuit case noted that this seemed armed hostility definition of an invasion is not intended to be used to combat illegal migration, and there it said to California that whether there is an invasion or not is a political question that is reserved to the federal government, and so it was not California to say it was being invaded if the executive said it was not. You can see where this is going, because now we are going to look at that case in a little more detail and talk about what happens when the shoe is on the other foot. Let's look at the case a bit more and unpackage what happened to see what kind of a shadow it may cast on our hypothetical. California asserted various constitutional and statutory claims premised on the impact of federal immigration policy on the state, particularly as it affects the state's fiscal burdens. California sought injunctive relief on idea that California was invaded and the president had to do more to protect the border. The courts had to decide whether it was an invasion that they could then order the executive to do more. And they said, no, this is not for us as courts. In some sense, then, if the show is on the other foot, would that mean that when the executive finds an invasion, a court would have to say hands off? It is a political question. There is a narrow basis to wade in when and if it is a manifest error, and that is long-standing Supreme Court law from the case Baker versus Carr that you will remember, of course. But that is narrow. To say the executive engaged in manifest error in invoking a Section 21 invasion prong decision would be a big statement for a court to make. Let's now look at the arguments on each side of this issue of the invocation of the invasion prong to address mass illegal immigration. We will start by looking at the arguments that exist to support the executive's invocation of the invasion prong to achieve a certain end with respect to certain groups of people entering the country. Now, at the outset, it can't be employed, obviously, to say that every person entering the country illegally is somehow a part of an invasion by a foreign government. Such a statement or claim probably would trigger the manifest error concept of the political question doctrine, and courts would reject it. But what if there is a more nuanced approach taken by the executive? For example, the executive concludes, based on the intelligence at its disposal, that the government of Venezuela has intentionally emptied its prisons of violent gang members and affirmatively sent them to America. Let's think of that fact pattern and now look at arguments. First, there is the fact that with respect to the war prong, as we saw in all the case law, there is very limited judicial intervention. In essence, the federal courts have said that the role of the courts is simply to look at the jurisdictional facts. Is there a war? Is there a citizen of a foreign country? If both facts are met, then there is nothing for the court to do. That analogy applied to the invasion prong would then support the idea that the president gets to declare an invasion by a foreign government. Perhaps even Congress issues a resolution to the same effect, and the courts can't really look under the hood, so to speak, as to whether it is really an invasion by a foreign government or whether it is simply mass migration by people illegally. Here, then, the courts may find themselves in a position of deferring heavily to the executive's conclusion that this is an actual invasion by a foreign government. Even if it is not an attempt to overthrow our country specifically, it is nonetheless some sort of predatory incursion or invasion, as found by the executive of a specific government sending a specific group of violent and/or armed people to the United States. Under the case law we have looked at, there is a fair argument that the courts do not get to second-guess very easily that determination. Second, the invasion language could be interpreted non-literally so that it is decoupled from the idea of war or from what was understood at the founding to be an invasion or a predatory incursion, and simply relate to the idea that there is a mass crossing of the border without consent or authority, which amounts in a sense to an invasion. And we can find, of course, some case law support for the application of the act outside the war context. Remember, several of the cases we looked at found the use of the act even after an actual war, as we conventionally understand it, was concluded. In those cases, even though there was no active fighting or hostility between the government of Germany and the United States after the summer of 1945, the Supreme Court still allowed the executive to conclude that the state of affairs was such that the act could be used to detain and imprison enemy aliens from Germany. That demonstrates that courts do not require there to be an actual war in effect for use of the act to imprison and remove people, and so that would support the idea that the invasion prong does not require an actual affirmative declaration of war by Venezuela against the United States, or vice versa, for the act to be employed more broadly. Finally, the political question doctrine, which counsels courts against the executive or legislative branch, would play heavily in the calculus here, especially given that doctrine has expressly been cited by many federal courts to justify a non-expansive judicial role in second-guessing. In other words, there are simply not judicially manageable standards to even assess and identify the existence of invasion beyond the jurisdictional inquiry of whether it has been concluded to exist by the executive or not. War and peace and foreign affairs squarely belong to the executive and legislative branches and squarely are not part of Article 3, and so that would support the idea that the executive gets an expansive playing field here. And we have even seen some case law that could be used to support the political question doctrine here. When the state of California tried to tell the federal government that it needed to do more because it was being subjected to an invasion in violation of the Constitution's invasion clause, the federal courts told the state of California that it had no business asking the courts to look at that because this was squarely something that belonged to the executive. Now, in that context, it was the executive not wanting to stop or do more about illegal migration. But the key holding is that it is not for the courts to address the executive's determination that there is no invasion. On the other foot, and the executive concludes there is an invasion, that doctrine and case law would support the idea again that it is not for the courts to second-guess that determination of the executive as to the existence of an invasion or predatory incursion perpetrated by a foreign government or drug cartel working hands in hands with a foreign government. For example, in our Venezuela hypothetical. So there we had the arguments for executive power. Now let's look at some arguments against it. First, the highly circumscribed judicial review in the war context was a function of the fact that both other branches of government were involved in making the determination of a war, and so that justified the courts not being involved in areas that they had no business being involved in. Determination could be seen differently by the courts because it is not something that is constitutionally vested in Congress to decide, and if it is simply something an executive gets to say because it wants to, courts may feel that they need greater judicial review as a check and balance on that use of the power. Even without heavy deference, the courts do have the right to figure out whether there is a war period that may be a simple question that delimits court review in the war context because of the congressional declaration. But if there is to be an invocation of an invasion, the courts, in order to have a full hearing under Section 23, look to figure out whether in fact what has happened is an invasion. Because there is no light switch test to go to in terms of an actual declaration by Congress, they may simply have to come up with a formulation of the meaning of the word invasion, put some meat on that bone, and then figure out whether this in fact is an invasion or not, notwithstanding what the executive has said. And if this is done, courts may well conclude that an invasion is essentially part of a war by a foreign government, or preparatory steps taken before an actual fighting war begins. And courts may conclude that even when in our hypothetical armed gangs are sent to the United States by a foreign country, those acts are not an invasion and are instead simply the act of that foreign country getting rid of its bad elements. If that definition of invasion is adopted, courts would be saying that this is not a statute that can be used to deal with what is fundamentally an immigration problem, as opposed to an actual war problem. And that courts may feel well within their Section 23 rights of judicial review of the act when used. Third, courts may conclude that they need to assess the metes and bounds of, because otherwise the statute could be essentially weaponized by the executive to deal with illegal migration, without any check or balance by another branch of government. That is, the idea of the four dissenters in the Watkins case demands judicial review, and that conception of judicial review may be more consistent with 21st century courts. Now, the counter to that would be citing to the Supreme Court case that we looked at, where they quoted that famous old case, which essentially said, we have to trust the vote of the people, and if they elect bad results, they will fix it at the ballot box next time. Whether courts would stick to that political question type premise of deep deference and an invasion invocation of the act seems less likely. This is another way of saying that the war prong has checks and balances and systemic fencing principles that justify limited court review. And courts may well conclude that the invasion lacks such checks and balances from the other branches of government, and so it requires judicial review of a more robust kind. Finally, there is the question that has not been litigated under the Act, but which, in our modern construction of equal protection and due process, may well require courts to assess the constitutionality of the Act and whether it engages in violations of due process or equal protection by referencing and concluding that natives based on where they are born are presumptively disloyal or dangerous. It also arguably raises due process questions about indefinite detentions, simply because someone is deemed based on their birth, ethnicity, or race to be disloyal potentially. Courts may today be more receptive to striking down this law because in our modern world there are so many other laws and mechanisms that the executive has to deal with illegal migration, from our vast criminal codes to our vast intelligence laws focused on finding threats and dealing with them. Courts may conclude that the government is well armed to deal with problems. And so this law, which may have been necessary in 1798, is not viable in the modern world, where we have different constructions of equal protection and due process. And based on that, courts may be more open to voiding the law. These, of course, are open questions without clear answers. We have looked at both sides of the question of this act and how it could be employed in the modern world in a narrow circumstances. And we have seen it as a question to be litigated with arguments on each side. So now you know the law, its history, how cases have treated it, and you are armed to discuss the scope of judicial review, political question doctrine, and different conceptions of the meaning of an invasion in our law. Thanks for watching, and stay curious and watch our other Curious Lawyer programs.